We thank you, Heavenly Father, for allowing us to meet here this evening. Please open up our hearts and our minds to the law, because all of this law is your law. We ask this through your Son, Yahushua. Amen. Do we have any announcements? Okay, go for it. Okie dokie.
There's a couple of announcements that I think we should be making or want to make. Number one, I told you last week that Victoria's Texas San Antonio seminar workshop had been canceled, and that was allegedly the last one she was going to do here 2003. We lied. She has scheduled one up now for November 21st, 22nd, and 23rd in the Seattle-Tacoma area. And I believe also Robert Kelly and some of his friends up there are trying to get her up there to Oregon, Southern Oregon, too, sometime. I don't know if that'll be by the end of the year or not. But if you're interested in either of those, particularly workshops, particularly the one in Seattle, which is pretty much being scheduled now, you can find out more details as they become available on Victoria's website, which is www.angelwiththeinkwell.org. No spaces, everything run together, all lowercase. And go from there. Also, let's see. Sam Davis is going to be November 15th and 16th at Colorado Springs, Colorado. We want to announce that particular seminar. If you're in that area and get a chance to go see Sam Davis and support the group that's putting that on, Andrew and Sandra are putting that on, contact them. You can contact Andrew for information at area code 719-237-7646. That's for a Sam Davis seminar, November 15th and 16th in Colorado Springs, Colorado. Should be a pretty time of year down in that neck of the woods. So that is a second announcement. Okay, Caleb, were you going to talk about the fact that the tapes are available or will be available for our Sabbath study for those people that might be interested in them?
You did a good job.
I just did a good job. Okay, so if you're interested in the tapes, specifically what we are doing or have been doing the last couple of weeks, I believe we have 3 audio tapes available now, is we've been going through Stephen Jones' book Creation Jubilee. And Creation Jubilee is Stephen Jones' analysis of the history of God's overcoming people from the birth of Adam, or the creation of Adam, down to the present, divided up into 49-year chunks, which is a jubilee. The 50th year is the tail end overlap of the 49th year. And so he is analyzing the history of God's people in terms of Jubilee studies. We had done the first couple of pages out of that book on a Monday night tape here a couple of weeks back because it had just an uncanny parallelism to what's going on in the civil court systems in the world right now, particularly in this nation. And part of the things that we've been doing as we go through Creation's Jubilee is try to make references to the teachings that Stephen Jones is bringing out on a spiritual basis with how it relates back into the civil law form also. Caleb, do you have a comment?
Just for the virtual audience, the people that are already on that tape list for the Sabbath studies, that have been receiving them, they'll automatically get them. This is just for anybody new that might want them.
Okay. One of the things that we were doing a little bit last week that was kind of extremely interesting, just by matter of fact, is that the flood came at a period of time early in the history, but the time that the children of Israel left Egypt was in time for the 50th Jubilee, which is 50 times 49, or basically 50 times 50, about 2,500 years from the time of Adam. And had they elected at Mount Sinai, when the spies came back from looking at the land of Israel, the promised land, had they elected to go into Israel, they would have crossed into Israel on the 50th Jubilee, which is a Jubilee of Jubilees. And if you people understand what the concept of a Jubilee is restoring one literally to all his rights, possessions, and inheritance. And so the 50th Jubilee was a very relevant occasion to restore God's people to the same state of grace that was occupied by Adam and Eve prior to their fall into sin. However, you will notice that they took a democratic vote, and because the majority of the spies said it was impossible for them as a puny little nation with no help whatsoever, even though the Father Creator was on their side, they elected not to go into the land. What they basically did is gave up their titles, gave up their restoration into a condition of grace again, and into a restoration of the promised land, heaven on earth. If you take a look at what happened in other succeeding times, it's really kind of interesting, because at the time of the coming of the Messiah on earth, and his death, that was the 80th Jubilee. And 80 in numbers, 8 is new beginnings, 10 times law. So his death on the cross was at 80 Jubilees, which is a new beginning, which definitely brought in the period of redemption based on his death to underwrite and close all the accounts. If you look at some other timing, which is very uncanny in its reality, you will see that the 120th Jubilee occurred in 1986 in the fall. And this is particularly interesting because it was a period of 40 Jubilees after the Messiah's death, which is a period of testing. You're in the wilderness, you're waiting for something to happen. And so in 1986, the Church of the New Testament had gone through a period of 40 years, if you will, or 40 Jubilees in waiting. A probation period was up. Probation for what? And for what was to come. It's also extremely interesting that the 120th Jubilee, which is in the fall of 1986, was exactly 70 Jubilees from the time that the children of Israel had the opportunity to go into the promised land and restore basically heaven on earth, the Garden of Eden. Now, if you remember, a Jubilee, 50 years or 49 years, applies in domestic law to the restoration of one's rights within the domestic kingdom. And so God's people were under 50 Jubilees of restoration from the time of Adam to the time that they could go into the promised land. That was domestic. But after God's people went into the promised land, and they went in 40 years late, which put them off of God's timing schedule, so that their restoration in the land was de facto shadow and not de jure lawful. It turns out that eventually, when the northern and southern tribes split, and the northern tribes got scattered all over creation by the Assyrians that captured them, took them out of the land and displaced them and replaced them in foreign lands, it turns out that the period in which a nation would serve out its sentence for having been in dishonor or in debt, if they are put in an iron yoke and dispersed overseas or in foreign lands, is usually a period of 70 years. And so it's extremely interesting that the 70 jubilees of that distribution was up in the fall of 1986 also. And so these are exciting times that we're living in. And one of the points that Stephen Jones makes is that usually right kind of dead on the time that one of these cycles are up, there's a lot of times that there's a transition period of times in terms of years or maybe even several decades there before whatever is changing or is supposed to change changes. And so this concept that a number of long-term cycles that have incredible implications in terms of granting the overcomers or God's special people certain dispensations have occurred here in very recent years. And in fact, by the year 2006, we would have 20 years after the 1986 time frame, which in itself is a redemption period after the end of the coming out period of the punishment or the penalties. And so as Caleb and I and some of our friends in our Bible study are going through these cycles that are being set forth and taught by Stephen Jones from a lot of the ancient texts and a lot of the ancient knowledge of what was going on in terms of times and chronologies in Scripture, it's becoming very kind of relevant to a lot of the things that are happening also today in this civilian world in a parallel put one-to-one in place of these spiritual timing cycles and stuff that we're seeing. So if you're interested in those tapes, get in touch with Caleb, and we hope that you enjoy them. Most of the work on there is Stephen Jones, and he's done some incredible stuff. Number of interesting things have been happening. I continue to have people in the background that I'm tutoring in various procedures and proceedings using a lot of the material that we're talking about here. Needless to say, there are many, many, many patriots and people out there, not just to mention people in the public, that really don't appreciate or have a clue what's going on when we talk about acceptances, closures of cases, settlements, all these kinds of things. I'm going to read you and talk about a couple of examples tonight to show you the kinds of feedback we're getting in some cases, and to show you that between the lines coming back from some of the judges and some of the other public officials, a lot of this is very incredible. We had my one friend out west in Wisconsin. I think I've been telling you that he has had a case going both in the state courts and a case going in the federal court out there. He's alternately been in and out of jail prior to any of these cases even going to trial or being heard. It appears as though most of the time he goes to jail, he's in a dishonor or contempt in some way, shape, and form. At least he's had a blessing to be able to come out and had some liberty so that he can talk to people, learn some teachings, things that are going on. He is the gentleman that back in June of 2003 fired his attorney because, as he said, he didn't want to grant the court jurisdiction by having an attorney. He started talking to me in late July and August again, saying, boy, things aren't looking good. They're going to trial. What can I do? I asked him what he'd done. He said he fired the attorney so that he wouldn't grant the court jurisdiction. I said, well, listen to me. I think what you're doing right now is granting the court jurisdiction by acting pro se, that you need to have a counsel back to represent the straw man, that the whole issue is whoever represents the straw man being their creation, their corporation, which basically they create. It lies in the land of the fiction. They hold the paperwork on that corporation. Therefore, whatever they want to do to that corporation, theoretically their court system is open to do it. You're not an officer of that court. You're not even a member of the land of the dead, which is what the 14th Amendment created. It created a political system of the dead instead of a political system of the living. And maybe you want to reconsider your position. Anyway, this gentleman did. He did letters rogatory to the previous attorney and explained to him that he needed some documentation put into the court. On the public side, please do it. He sent copies of that letter rogatory to the prosecutor, the judge, and the clerk in the case. Unfortunately, he mailed them all at the same time. So the people that got it first told the attorney what was going on, and he didn't accept or receive his paperwork of originals, sent it back. My friend called me up and said, oh, the guy from the post office was here. He wants me to sign for all these documents coming back. I don't think I want to sign for them, do I? What do I do? And we suggested that it would be a dishonor not to sign and take them back. Take them back, don't open them, write a new letter rogatory to the prosecutor, who is the only other counsel or official that he knows that works for the court, and instruct the counsel by letter rogatory to put them in on the public side. And part of the paperwork, of course, was requesting that the prosecutor or the court appoint a replacement attorney to defend the defendant, who is not our hero. And that paperwork got to the prosecutor, didn't come back. The federal judge wrote a couple of letters privately out of chambers, acting like, gee, I don't know what's going on here. This guy is so confusing. I thought he was representing himself. Now it appears as though maybe he's not. Hey, buddy, would you come in and testify and let us know what you want to do? And, of course, we said, don't you testify. If you testify, you've become the debtor in their court. Just accept it for value, return it for value, and ask once again if that isn't the job for a counsel and you believe that somebody ought to appoint counsel to represent the defendant. The judge finally, after 2 or 3 private letters, put on the notice of the court that they were hiring an attorney now to represent this guy, and that if and when this guy ever does not cooperate with this attorney or plays silly games and stupid games again, that's it. This patriot's going to be on his own, and he's going to be pro se, and it will totally relieve the court or anybody of having to once again provide any counsel whatsoever for the defendant. And it will be deemed as though if he basically dishonors this new attorney by not cooperating with him or whatever, that it will be deemed that he, the patriot, has intelligently, articulately, and voluntarily chosen not to have a counsel appointed by the court, and he's chosen knowingly and logically to be on his own. And so the judge appointed a new attorney. This new attorney called up our hero. And when he called up our hero, he says, "Hello, I've been appointed to go ahead and to represent you," i.e. the allegation of the defendant, "in this case. I've been reviewing some of your paperwork here. You need to come down and talk with me." To which our hero said to this attorney on the phone something to the extent, "You got all my paperwork. There's nothing that I really have to do or to provide for you other than the directions that I have requested of my previous attorney, i.e. accept, settle, close, exchange the exemption. I don't believe I have to come down and chat with you." To which the attorney then said something about, well, he didn't quite understand something. To which our hero then said to the attorney, "By the way, I have requested that the previous attorneys, and that includes you, file the documents that I sent and provided on the public side of the court. Have you done that?" And the attorney's voice on the phone came back and said, "No, I haven't. Those papers are stupid and ridiculous. They have absolutely no legal basis. I'm not even sure what you're trying to get at. That's one of the reasons why I wanted you to come down here and talk with me, and I'm not going to file them." To which our hero said to the attorney, "If you're not going to file them, then I believe you're ineffective counsel." To which the attorney's voice on the other end of the phone then said, "I believe that I am going to move to withdraw from this case." To which the hero said, "You do what you have to do," and hung up. The next day in the mail, our patriot hero got a letter from this new appointed attorney. The new appointed attorney had drawn up a letter stating exactly about what had transpired on the phone and informed the defendant client that he was putting in a motion of the court to withdraw. This was Thursday. He got it Friday. Saturday morning, he got a notice, the patriot, from the court that there was a motion hearing for withdrawal of the attorney on Monday morning. He went down to the hearing on Monday morning kind of shaking in his boots. He went in. There was hardly anyone in the court except the federal judge, this attorney, himself, and a couple of the judge's people. The attorney stood up and said to the judge, "I'm moving for withdrawal, da-da-da-da-da-da-dee-dee." He spoke for about like 2 or 3 sentences. It took all of about 40 seconds. In the next 30 seconds, the judge excused him and he was out the back door, all in a minute and a half, leaving our hero standing in court. The judge read the riot act at our hero, informing our hero that the court would not and cannot and does not intend to appoint any more legal counsel. That as far as the judge is concerned, the defendant is on his own. And he is knowingly and willingly elected to represent himself pro se. And that furthermore, even though it's the beginning of November now, there is going to be a pre-trial in 2 weeks in the middle of November for which he ought to be there, and he better have all of his motions in for pre-trial before December, and the trial is going to take place in the middle of December. And as parting words, the judge said to him, however, if you believe that this court needs to appoint an attorney for you, you may file an affidavit privately with me, and I will consider it. Hearing adjourned. What just happened? Say what? First of all, what's going on here? Every time you go in front of a judge, it's a debtor's hearing. Every appearance in court is a debtor's hearing. And the debtor's there to show cause or testify. What did our hero do? Well, our hero told the judge that according to Supreme Court case law, the court can't try anyone without counsel and send him to jail. What just happened here? He what, John? Oh, no, not at all. Just the opposite. Look, he was on the private side when he was separated from the defendant because there was a court-appointed counsel to represent the defendant. What had the judge told him when he appointed like the second or third attorney to go ahead and be in this position? What did the judge say to him? If you don't cooperate, the court will never appoint another one. Is that lawful for the judge to say that? Well, sure it is, because if he doesn't cooperate, what is that? A dishonor. And who's going to be penalized based on a dishonor? The person who dishonors. So it's like, hello, whether or not you keep your separation from the public by having the court appoint the public counsel to represent the public defendant is based on your staying in honor with the public side of the court. Now, remember the attorney called him up. You know, the attorney had all the paperwork, which is exactly what our hero told him, right? You've got all the paperwork. You know everything that's going on, right? And so our hero's going, what do you need me for? Just take a look at the paperwork. Hello, too much truth. And their public system doesn't deal with truth. It deals with color. See, the whole issue is you got to have a double witness. Remember, you go right back to the movie Men of Honor. You have Robert De Niro, who understands what honor is. Honor is when you respect your fellow man and you do things which are substantively good. You got two pilots in the water drowning. Honor is when you jump in the water because you got your diving suit on and you're safe. That's honor. Right? Answer's wrong. That's only half honor. Because his superior officer ordered him not to jump in the water. So on the public side, which is the orders coming from his superior, he's not supposed to go in the water. On the private side, he knows that these guys will die if he doesn't jump in the water. He's willing to risk his own life to possibly save two other lives. To him, that's honorable. But he made his own decision to do that on the private side without concurrence from his superior officer giving permission. The point is, everything about that movie or that story, Men of Honor, was showing you that if you don't get honor both in the private and the public sectors at the same time for the same circumstance, you haven't got a double witness and you're in trouble. So here is our hero saying to this attorney, you got everything you need, why do you need me down there? Of course, our friend was a little worried if he went down there, the attorney would try to trap him and he may say something wrong and he didn't want to do that. So he's kind of being extra cautious and he's trying to be defensive. But when the attorney says, come on down here, it's a dishonor to say, I'm not coming. So here's the attorney. He was probably told by the judge, call this guy up and see if you can get him in a dishonor. So within 2 minutes on the phone, he said, come on down. And the guy says, no, I won't. Beep, dishonor number 1. Then they got involved in a discussion about whether or not the attorney was going to file the private documents that our hero directed him through his letter rogatory to file. And the attorney starts off on, no, I'm not going to do those. Those are pieces of crap. They're incomprehensible. They're stupid. That's patriot garbage you got off the internet. I'm not going to do it. To which our hero comes back, and what does he do then? He charges the attorney with being incompetent. What happens when you charge your brother? It's a dishonor. Dishonor number 2. The attorney goes, that's enough witnesses for me. I'm just here to inform you. I'm putting in my resignation. Did that attorney understand the conditions on which the court hired him? Absolutely. He was there to test our hero. He tested our hero. He found our hero wanting. He immediately went to the court and he told the judge, no, this guy's an imposter. He doesn't have a clue what he's doing. And so the judge says, fine, you're off the case. Put him on the case, which grants the jurisdiction. And it's obvious he's dishonoring all of the counsel the public is allowing him to have. So it's his own fault that we will sanction him by giving him no counsel. Who's right and who's wrong? The court's right. Who's wrong? The patriot hero. Now, we don't take glory in seeing our friends go down the tubes. But what is amazing is I am getting telephone calls from people that are picking up on the material that we're trying to teach. I'm getting calls back from people that have been asking me questions and tutoring with me. And they keep coming up, and this guy's going, woe is me, what am I going to do? Was I right? Was I wrong? His point of view was, that attorney dishonored me when he didn't do what I told him to do. And so he dishonored me first. That was his position. So this guy on the phone is saying, it's not my fault, man. It was their stinking attorney. He didn't do what I told him to do. I said, who told you he had to? He said, well, he's in dishonor. I go, is he public? He goes, yeah. I said, are you public? He goes, no. I said, who is the sovereign? Who runs the case? The public or the private? He goes, the private. I said, so you want to run the case, so you went to your servant and told your servant off. Is that what you did? He goes, yeah. Because he wasn't doing his job. I said, okay. So you treated him, number one, like you were the boss. If you would be great, first you must be what? Least. So pride comes before the fall. You treated your servant like a numbskull and took on the persona of a genius. And then the judge took you down a peg or two and put you in charge of the defendant so there's no way you can win. Is that what you wanted to accomplish? He goes, no. I said, did the judge deny you your remedy? He goes, yes. I said, no, he didn't. What was the last words the judge said in court? Remember, Scripture says the last will be first and the first will be last. So if you want to know what's the most important, you go to the last, and that's first. What was the last thing he told you? Bring the judge an affidavit explaining why I ought to appoint another attorney, and I'll consider it. I said, what kind of affidavit, and what's the contents of the affidavit that you got to bring to the judge to get the attorney? Well, it's in the nature of a letter rogatory. What's the contents? No, not an affidavit of poverty. It's irrelevant and immaterial. The judge was appointing an attorney, never asked him whether he had any money or not. Apology. The judge in the court is looking for an apology. He's in dishonor because he acted like an SOB. He's got to apologize to the court for his misbehavior. And then he's going to have to do what the judge told him last time. Say, I'm trying my darndest to stay in honor here, and I promise to, within the powers of my ability, not to go out and dishonor any new appointees. You understand what's going on? See, when that guy came back and he told me what he did, and he told me what the lawyer did, and he told me what the judge did. This is a federal court judge. Man, this ain't a traffic court podunk guy. The judge never denied him anything. Remember, this guy said to the judge, you can't not appoint an attorney or you can't put me in jail. Hello. First of all, he's bringing out public case law. What's that mean? He must be on the public side if he's raising public case law. Not only that, he's threatening the judge with a reversal unless the judge does what he tells him to do. And he's not saying to the judge, hey, judge, I'm going to stay in honor. Please don't screw it up. He's just saying, nah, judge, I can be in dishonor all I want. And the case law says you got to give me to counsel anyway. Even if I mistreat the counsel, even if I dishonor the counsel in this court, nah, you can't do nothing to me because case law says you gotta. Hello? Yeah, there you go. Gives him the guy and puts him in jail anyway because of his habitual extended dishonor. You understand what we're saying? What's interesting is that the people that are in the trenches, going into the trenches and doing whatever it is they're doing, sometimes they do it right and it's incredible what comes out. Sometimes they still screw up and it's just as incredible what comes out of the mouths of the public officials when they screw up, because it doesn't make any difference whether they do it right or whether they screw up. The public officials come back and dance with them in parallel to whichever way these people are leading the public officials. The importance here is that even though every incident is its own transaction and there's all kinds of variables and variations upon which the public can play the game to test the private people, they always do something which, in the logic of our explanation of honor and dishonor, tends to be in harmony with our teachings of what it takes to be on the right side of these people. so that they will honor and respect you if you honor and respect them. See, most of the patriots going into court have assumptions and presumptions that they're going on. Like, I don't think there's any law for taxes. Therefore, when I get in the court, I'm going to argue that there is no law. I'm going to try to educate them. And I'm going to stand back, and they're going to see how articulate and knowledgeable I am, and they're going to give me the result that the findings of fact, conclusions of law are that I present. And then they all come out of that court shaking their head going, gee, you didn't pay any attention to anything I said. And they're confused by the fact that their belief pattern involving procedure, argument, and substance is not equivalent to the results that they're seeing from the public officials as a result of the transactions that are going on. What I'm suggesting to you is if you're going into the court not on the facts and not on the arguments of law or fact, but you're dealing with substance and form in terms of honor, you start getting interesting responses that are in harmony with what makes sense. It's not opposite to what you might expect. I'm going to give you another example here. Here is my friend Dennis off in the east. Remember, he's the guy that was supposed to have gone into sentencing after a jury trial convicted the straw man back in June or so. He was supposed to be sentenced in August, and he's still not sentenced. This is the guy that came in and did the acceptance for value, return for value, the letter rogatory to his attorney, told his attorney to put it on the private side of the court. The attorney followed him for about 2 months and then came back and said to the judge that I want to be withdrawn from this case. What is of interest is where they're going now, and I think in the last couple of weeks I probably indicated to you that one of the things that happened is his attorney, previous attorney to the strawman defendant, indicated to Dennis when the court granted the motion to withdraw, he told Dennis privately, if there's another attorney appointed, I'll be happy to assist him in whatever way possible in order to expedite this case. And so Dennis has been using him in his private capacity. But then Dennis, I told you, I believe last week, had this notice to go down to Public Defenders Are Us because the court said, hey man, I think they ought to take the case now. And when he got down there, there was this intake secretary or something that said, oh, you tried us before and you don't qualify for public defenders, i.e. your income or something was way too great. And so I said, don't argue, just do an acceptance and whatever. And also there was an indication that he had to go down and have a mental competency exam. Well, he's gotten some extra documentation now. Here is an order, copy of the order that came out of the court. I'm showing you right now. There was about 2 sentences typed. And the typed sentences say, the motion of counsel to withdraw having been heard and considered, it is hereby ordered this such and such a day that the attorney is hereby relieved as counsel of record in this matter. Now, if you notice, the whole page has hand printing on it. So obviously, this was way too simple for this more complex issue in the court. It now reads, the motion of counsel to withdraw having been heard and considered and a hearing having been held where defendant was present and the state having no opposition, it is hereby ordered this 20th day, redemption, of October 10th under law, 2003, 20 is redemption again, 3 for the church, that the attorney is relieved as counsel of record in this matter. It is hereby further ordered that defendant shall undergo a psychiatric evaluation at the such and such state hospital within 45 days. That hospital will provide a report to the court within 15 days of the examination. The court would like the psychiatrist to evaluate defendant's competency, in particular his competency to make decisions about his case, his competency to appear at sentencing, whether he is able to understand what he is going to be, that he is going to be sentenced, and whether he understands he should have legal counsel. Defendant shall be interviewed by the Office of Public Defender within 5 days to determine his eligibility for representation. So those are the 2 marginal additions to that order that came out. Now, he got a letter from the psychiatric place addressed to him. You have been scheduled for an evaluation